Hello, everyone. Good afternoon. Thank you for joining us for this critical webinar on the Office of Management and Budget's proposed regulations on federal financial assistance. And a special thank you to Innovate EDU for hosting this webinar and for arranging this conversation and for everything that Innovate EDU is doing to support the education and research communities and others in navigating these rapidly changing times. My name is Dan Gordon. I work at a mission-driven consulting firm called Education Council, based here in Washington, D.C. I help coordinate our work, tracking and translating the administration's actions affecting education from early childhood through K-12 and in higher ed. But today, I'm just playing the role of cruise director, as we're joined by two national experts to help you make sense of what the administration is proposing in this OMB proposal and how you might respond in public comments that are due on July 13th. Do a quick intro of these two great folks. Amy Berman is currently the Deputy Director of the National Academy of Education, where she advances the strategic and research initiatives of the National Academy. Prior to that, she was an education civil rights lawyer as an enforcement director at the U.S. Department of Education's Office for Civil Rights, and she was the acting section chief and principal deputy at the U.S. Department of Justice Civil Rights Division in the Educational Opportunities section, where I was lucky enough to be her colleague. I'm also lucky enough to be current colleagues with Amanda Dallow, who's a principal at Education Council, where she provides legal policy and advocacy services focused on improving equitable educational opportunities. Before joining a council, Amanda was at the office that I just mentioned with Amy. She was the deputy chief of that educational opportunities section at the Justice Department. And she previously was an attorney at the U.S. Department of Education's Office for Civil Rights. So when it comes to these issues across the government, we have you covered. We're going to start with Amanda, who's going to give us a breakdown of what's in the OMB proposal on federal grant making and federal financial assistance. Following that, Amy will join us to give sort of tips and suggestions and advice for how to make effective comments, particularly in this context, and how both organizations and individuals can respond to OMB's proposed rule. Finally, we'll have time for some Q&A. There's a Q&A function in this webinar, and please feel free to submit questions along the way. I'll be sort of reviewing those and pose some of those questions to Amy and Amanda, depending on how much time we have remaining and what you all are still wondering about. Before we move on, I just want to note a couple things. The personal opinions expressed during today's webinar are personal statements by Amy and Amanda and don't necessarily reflect our organization's priorities or advocacy. I'm contractually obligated to note that none of this constitutes legal advice. And so if you want legal advice, we recommend that you seek counsel from your attorney. And then a couple of additional housekeeping notes. First, Amy and Amanda's presentations will be recorded, although the question and answer section at the end will not. And then following today's webinar, our friends at Innovate EDU will circulate both the recording of the webinar and the slides that we're be using today. I think that covers all of our upfront stuff, and so I'm just going to turn it over to Amanda to let us know what is the federal government proposing.
Great. Thanks, Dan. Good afternoon, everybody, and thanks for joining us, and thanks to Innovate EDU for hosting us for this discussion about OMB's proposed regulations on federal financial assistance. Can move to the next slide, please. Okay, so I'm assuming that if you all are here, you already know that the administration, through its Office of Management and Budget, has proposed a set of regulations, also called a proposed rule, that would significantly alter the federal funding environment. If finalized, the rule would restrict how federal funds can be used and would change how agencies make, monitor, suspend, and terminate awards. The scope and impact of these regulations would be huge, spanning across federal funding agencies and touching every sector that receives federal financial assistance, but it would have particularly harmful effects on funding for education, research, and nonprofit recipients. So we want to recognize this as part of a broader pattern by the administration to assert its legal positions and policy priorities around issues involving things like DEIA, gender identity, and immigration, among many other things. And the administration has used many levers to do that, ranging from executive orders, agency guidance, enforcement actions, and of course, limiting the federal funding process. On that point, I want to give just a 1-minute refresher and update on another administration attempt to leverage the federal funding process because I've gotten a lot of questions about how these two things relate to each other. So as some of you might remember, a few months ago, the administration proposed changes to its certification for SAM.gov. That proposed certification would expand its own requirements to cover many of the same issues covered in this OMB proposal that we'll discuss today, including things like DEIA, immigration, and fraud. But the GSA effort is separate from OMB's proposal. And in many ways, it seems like the administration even learned some lessons from that process, because what we see in the OMB proposal is that it contains more legal caveats. It says things like this very problematic provision only applies to the extent permitted by law, which was really largely missing from the GSA proposal. And that GSA proposal is still pending. This doesn't delete that or eliminate that or postpone that. And it's on a different track than this OMB proposed regulation. So we will just have to see how those progress. We expect when the GSA certification, unless it's dramatically changed from the proposal, we expect that any final change would be challenged in court, and that would be true regardless of what happens with this OMB rule. And we can move to the next slide. OMB issued this proposed rule at the end of May, and the proposed rule would expand its existing non-binding guidance for federal agencies and convert it into a binding regulation. OMB is issuing the proposed rule as a joint rule with dozens of other funding agencies across the government. So if this rule is approved, it's not going to matter whether you got your grant from the Department of Ed or HHS or NIH or NASA. All of those agencies have signed on, and this rule would apply across funding from all of those agencies without a separate comment period. So please pay attention to the deadline for public comments on this slide, which is July 13th, and we'll obviously talk more about submitting public comments later in the presentation. But as we think about the content of the regulation itself, we can really divide the proposed changes into two big buckets. One are substantive changes, what the federal agencies fund, and the other are procedural changes, how the federal agencies fund. And I'm going to walk you through some of the highlights or lowlights, I guess, of the proposed regulations, but just know that there's a lot more in there than we'll actually have time to cover today. Moving on to the next slide. So on the substantive changes, OMB proposes restrictions and bans on the use of federal funds for a really wide variety of issues. A lot of these issues are going to sound very familiar to you as aligning with the administration's major priorities. So you're going to see restrictions on related to the consideration of race, sex, and disability, issues related to gender identity, immigration, anti-American values, which we'll talk about in a minute, but query what that means, disparate impact liability, any type of funding that is counter to the president's priorities, voter registration, issue advocacy and lobbying, abortion funding, and a provision we'll talk about in a minute on viewpoint neutrality. Okay, next slide. So drilling down on some of these provisions, there are two provisions that would prevent the use of federal financial assistance for diversity, equity, inclusion, and accessibility related efforts. Those provisions do seem to be limited to DEIA policies that violate federal anti-discrimination laws. So that limitation hopefully does provide some protections in the sense that recipients are never permitted to violate those federal laws. But the devil is really in the details here, because the funding agencies who control the flow of that money will be in the position to say whether a recipient's practice violates federal law. And this administration's interpretations of civil rights laws certainly do not always align with what the courts tell us violate those laws. So that is likely to have a huge chilling effect on applicants and recipients of federal funds. On gender identity, the proposed rule would prohibit the use of funds for gender transitions in someone under the age of 19, or using funds in ways that fund, promote, encourage, subsidize, or facilitate the notion that sex is a mutable characteristic, or the denial of the sex binary. Now, obviously, that's very broad and likely to chill a lot of protected speech and conduct. So, for example, does using a trans student's appropriate pronouns encourage the denial of the sex binary? I think that's really unclear from this language. Or does allowing a trans student to access housing consistent with their gender identity violate this provision and risk a university's federal funds? We just don't know, but it's very, very broad. The immigration provision raises some similar questions because it uses that same list of words that recipients may not fund, promote, encourage, subsidize, or facilitate illegal immigration. So here, again, very broad and really vague. We don't know what it means to promote or encourage or facilitate illegal immigration. Is, the if you are a nonprofit organization and you have a program that benefits all sorts of people, and it turns out some of those people are undocumented, does that mean that you could lose your federal funding? Again, we just don't know. One thing I think we can say confidently is that K-12 schools, because of the decision in Plyler, K-12 schools can, of course, and must continue to serve their undocumented students consistent with their obligations under Plyler. Okay, next slide. So on eliminating disparate impact liability, the proposed provisions would include a statement that agencies must eliminate the use of disparate impact liability in all contexts relevant to federal awards. That is a really sweeping statement, and they give a few examples. They say, including barring funding for disparate impact studies or litigation. Again, we're very concerned about the chilling effect here, particularly on research and research looking at that examines outcomes that differ by race or sex. So if you're thinking about things like maternal mortality rates in Black women or disparate discipline practices that disparately impact Black boys, is that enough to trigger this prohibition and risk federal funding? Again, we don't know. There is a provision that says discretionary awards would have to advance the president's policy priorities where applicable. And it says those words, the president's priorities. So not even, the public's priorities, but the president's priorities. That's really problematic on a lot of levels. First of all, presidents can change, their priorities can shift, and it makes it really hard for a recipient to know what they're signing up for or what their grant is supposed to promote. And then the where applicable is also funny. We really don't know what that means. So that term is really unclear and raises for us at least some possible separation of powers concerns. Really, Congress is supposed to control the purse strings here, and adding these types of really vague executive branch focused conditions on funding feels really problematic. There are separate provisions in the proposed rule that would bar the use of federal funds for voter registration efforts, issue advocacy or state lobbying, and the costs of elective abortions. Some of those restrictions, some of those activities are already restricted to some degree, but certainly some of this feels a little bit broader than that. And then I want to pause here because all of the provisions that I've talked about so far are restrictions on entities' uses of federal funds. This next provision is a little bit broader than that in the following way. It's a viewpoint neutrality provision, and it says that all public and private recipients of federal funds would have to treat speech neutrally when administering events. So think about things like a school district or a college or a university that might bring speakers to their campus. They would have to treat all of those speakers neutrally, regardless of their viewpoint. And what's notable about this provision is that it says there has to be viewpoint neutrality even when we're talking about the costs of putting on that program. So things like security. So it doesn't matter if a program is going to have an audience of 10 people or 10,000 people, you have to still be viewpoint neutral and you handle the costs of those. And that feels like something very different. It's also a little bit different than these other provisions because, as I mentioned, it goes in some ways beyond just federally funded activities. The proposed rule says that for public institutions, public recipients, because they are required to comply with the First Amendment, is the justification for this, the provision would require them to impose this viewpoint neutrality on all of their events, not just their federally funded events. The rule would be a little bit different for the private institutions. Private recipients would only have to do this for their federally funded events. Okay, moving on to the next slide. Okay, so this is some of the procedural changes. This is about how agencies award and manage their funds. And here, some of the changes I think are even more sweeping than some of the substantive changes, and they would really impact almost all federal funding on all topics out of all agencies. And so I hope folks are really paying attention to what's happening in this space. Again, a really wide variety. We'll drill down on a few of these, but there's a provision on pre-issuance political review. These would make termination and suspension of grants easier. They would expand agencies' ability to add special conditions on funding. They would require payment justifications. They would make more costs unallowable. The administration is trying to impose a domestic first framework, which we'll talk about in a minute. There's a big focus on science grants and nonprofits, actually, and on fraud and risk reporting. And then they would also ban fixed amount awards. So moving on to the next slide. Okay, so probably if you've heard anything about this rule in the media, the thing you have probably heard about is this new pre-issuance political review. And the proposed rule here would require agencies to designate a senior political appointee to approve all discretionary proposals before they go out the door. And that person would have to say that the proposals are consistent with the law, agency priorities, and the national interest. And so part of that pre-issuance approval process is looking at that list of all the substantive things that we just talked about and saying, yep, this proposal does not contain problematic DEI. We don't think it triggers any of the gender identity or immigration issues, so on and so forth. So a senior political official would essentially be doing that. And that's just a very significant shift. That is an infusion of political oversight in the grant making process that's really different than anything we've seen before. And here, the rule also provides some science and research specific obligations on the agency in the sense that it says you may still consider things like peer review recommendations, but you cannot consider them binding. The senior official has to use their own judgment in deciding whether to let a discretionary grant move forward. And there's no obvious requirement in the rule to explain that decision or to let a rejected applicant know that this is where the rejection happened. This is what happened. We reviewed your application. This is why it got flagged. It's not clear that agencies are going to be required to deal with applicants with that level of transparency, which might make it really hard to understand when this provision comes into play. And then thinking about the termination and suspension discretion of agencies, agencies already, of course, have discretion to terminate federal financial assistance, even in the middle of a grant, like during the funding period. But usually there needs to be some reason for that. OMB's current guidance does contain some ability for agencies to terminate based on, the government's needs or priorities. But here, this would be a real expansion of that to allow for mid-funding termination of grants to essentially suit the agency's interests or priorities, for them to be able to say, you got this grant, maybe under a different administration. We just don't think it functions as in our interest anymore, and we don't plan to fund it anymore. They would also be adding a suspension provision that would allow agencies to suspend grants for up to 90 days while they consider what to do. So that can also be very destabilizing for recipients because if you are relying on grant money, as I'm sure many of your organizations are, if you don't know at any point whether the administration might terminate or suspend your money, it's very, very hard to rely on that to operate your programs. And I think that's especially true when we're seeing some of the substantive changes that are going to be, overlaid on top of some of these grants. Next slide. Okay, restricted costs and fixed amount awards. So the new OMB proposal would move a lot of costs that are currently allowable, including conferences, fundraising, memberships, subscriptions, publications. It would move all of those costs into either a category of unallowable costs, so you cannot use federal dollars for it at all anymore, or restricted costs, meaning you would have to get pre-written approval from the federal agency before you could attend such and such conference or before you could use the funds in this way. This is going to have a really big impact, particularly on research, because if you think about things like sharing information at conference or publishing your findings, subscribing to different subscriptions that help, inform your research, all of that now is going to be restricted. That's a really big deal. Fixed amount awards are those awards that don't, they are essentially the recipient is getting a certain set amount of dollars to complete the project, and they typically have fewer bureaucratic hoops that folks have to jump through because as long as they complete the project, they get the set amount of that grant. This proposal would do away with fixed amount awards, and those are not the majority of federal financial assistance, but they are often used for seed grants, certain agricultural and health programs, and so they will have a really big impact there on projects where they're very important, but just small enough that someone might not want to go through all of the bureaucratic procedures that this new regulation is going to impose. The domestic first and gold standard science provisions are going to have a really big impact, especially on science and research. Again, we've talked a lot about science and research grants. These would limit research and development funding involving foreign entities, express statutory authorization, or a compelling interest for the agency's mission, the administration's priorities, and those of the United States. Now, what's interesting here is we don't really know the scope of this provision. So it's not clear what involving foreign entities exactly means. Science knows no boundaries, and often science grants are made in conjunction with, let's say, an author for an institution or who lives outside of the country. It's not clear whether things like co-authors would be covered as involving foreign entities. So again, the scope here could be very, very sweeping. The provisions would also require discretionary science awards to commit to a 9-fact gold standard science framework, which is a framework that was created by an executive order earlier in this administration. And the application of that framework remains very unclear. It's not clear to me, or I imagine the science community, what they are supposed to do with that 9 framework. In this proposal, the administration also focuses a lot on fraud and expanded risk factors. And by risk factors, I mean how risky is a particular recipient to give money to. If everybody has been following along at home, we know that the administration has a focus on fraud with respect to certain groups, and this is really a continuation of that. So fraud allegations are received by an agency's Office of Inspector General would have to be referred to the U.S. Attorney's Office for D.C. within 10 days. A list of factors that agencies would be considering in assessing whether funding applicants are risky would expand and would include things like past performance and affiliations with organizations that are tied to unlawful activities or activities that undermine public safety or national security. That raises a lot of First Amendment concerns. We, of course, have a right to association, and it's not clear how the administration would be using this to say, we're going to pull your funding or not give you funding based on the entities that you associate with. Okay, so very quickly on this last slide, just want to give you a few key takeaways. OMB's proposal, just as a reminder, would convert non-binding guidance into binding government-wide regulation that would affect nearly all forms of federal financial assistance. The substantive restrictions target DEIA, or identity, immigration, disparate impact, and lots of other politically disfavored topics, generally, but not always limited to the use of an entity's federal funds. Procedural changes would give political appointees a lot more control over awards and make it easier for agencies to terminate or suspend funding. And many provisions just overall use vague and undefined terms, which creates a lot of uncertainty for recipients and risks chilling them from applying for federal funds or applying for federal funds for some very necessary purposes that they may think fly in the face of some of the prohibitions. Most importantly, public comments are due July 13th, and they're really a meaningful opportunity to shape the final rule and build the record for future legal challenges. And I'm going to let Amy tell you a bit more about that.
Thank you. Thank you, Innovate EDU, for co-hosting this with us and for all of your assistance in organizing this. Thank you, Dan, for the introduction. Thank you, Amanda, for the really important summary of the proposed regulations and its larger context. And thank you all for joining us today. This section is about how to submit a public comment on the proposed rules, where to go, and how to make sure your voice is heard on the record in a way that carries real weight. Next slide, please. And excuse me, I'm sorry, I'm getting over a cold, so all this congestion. Okay, so before we get into the mechanics, let me explain why your comments are important. The first reason is a legal one. Under the Administrative Procedures Act, or the APA, agencies are legally required to consider all significant comments and to explain in the final rule why they rejected material issues raised. A final rule that ignores important comments is legally vulnerable. Courts have struck down rules on exactly this basis. So when you submit a comment, you're not just expressing an opinion, you're creating a legal obligation to OMB to respond. And this leads me to the second reason. All comments become part of the official administrative record. If the rule is challenged in court, and if this rule goes forward, it almost most certainly will be, courts review the administrative record. So judges look at what concerns were raised and how agencies responded. If commentators raised specific legal or factual problems and the agency's response was inadequate or dismissive, that gives challengers ammunition. A court could strike down a rule precisely because the agency failed to meaningfully grapple with a significant objection that was right there in the record. So your comment doesn't go into a void, it actually becomes evidence in these court cases. The third one is that it works. Amanda pointed out one of the examples that OMB has sort of narrowed the DEI prohibition to, quote, unlawful DEI. That's in response to prior public comments on this issue. While this term is still vague and we're unclear exactly what it means, we are seeing that comments do matter. Also, just this past year, the Department of Energy filed a notice and comment on a rule concerning Title IX, and it received so many comments that it withdrew the rule. Finally, quality and quantity both matter. With 3 weeks still to go before the July 13th deadline to file, there are nearly 40,000 comments. This volume signals that this rule has broken through to the general public in a way that uniform guidance changes almost never do. So most rulemaking on grants administration attracts hundreds of comments, maybe a few thousand if it's controversial. Nearly 40,000 this early suggests a coordinated mobilization by universities, by nonprofits, scientific societies, and advocacy groups, but it also demonstrates individual researchers, educators, and community members are making a stake in saying that they understand and that this matters. So I've looked through some of these comments already, and they're strong and they're important, and we really need to continue to build this record. Next slide, please. Okay, so this is the nitty-gritty of where and how to submit, and we just put into the chat for you where to submit and where to read the proposed regulation. So most importantly, as Amanda has said, and we keep highlighting, they are due on or before July 13th, and they can only be electronically submitted. So your name and your professional affiliation strengthen your comment, though I'll mention in a moment that anonymous submissions are also permitted if you have concerns about that. Now, OMB has requested, and I want to be clear, this is a request and not a legal mandate, that you begin your comment with the relevant section number in brackets. When I downloaded the proposal from the link that you have on that review, it was 242 pages, which is likely why OMB is requesting that you add section numbers. So for instance, if you're addressing the payment justification provision, you'd start with bracket 200.305 and bracket. This is going to help OMB route your comment to the right staff and signals to any reviewing court that you're engaging with a specific provision rather than making a general objection. And these section numbers will later correspond to sections in the Code of Federal Regulations if this is ultimately codified. So many comments will likely refer to multiple section numbers, and I'm going to come back to this in a minute. But this slide does have an example of a format just to give you a starting template. So you would bracket a number, you'd identify yourself, and you'd describe why that specific section would impact your organization's operation or your work. And that structure will work for most of the comments. Next slide, please. So what actually makes a comment work? Specificity and quantification are the most powerful elements. Be specific and use concrete data and examples to explain the harm when you can. Pick a few provisions and address them by their section number. Like a sweeping statement that this entire rule is harmful to science without any specific backing isn't going to carry much legal weight. But this entire rule is harmful to science. And there are a lot of specific provisions in here that Amanda has just gone through that explain why that is true. And so making that statement and then citing to these sections and why it is harmful is what is going to be most powerful for these comments. Explain who you are. If you're filing on behalf of an organization, state your mission and how much federal funding you receive. If you're an association, explain who your members are and how this will harm your membership. And if you're an individual, state your role and your relationship to federal grants. It's important to flag vague language and legal conflicts. Identify undefined terms. Anti-American values, which Amanda just talked about, is one of the most obvious examples. Explain, though, what compliance decisions you would face when you're faced with such an unclear term. Point out where the rules conflict with existing laws. Regulatory vagueness isn't just a policy complaint, it's a legal argument. And I'll talk more about that in a minute. Additionally, suggest specific deletions or if you have proposed alternative language. For many of the provisions Amanda pointed out, my suggestion would be that they be entirely deleted. And that can be your recommendation. Finally, you can also affirm what works. If there are provisions you support, you can mention them. From my review, this regulation is so problematic that I believe, and as Dan said at the beginning, these are our beliefs, I believe it needs to be entirely struck down. There are some worthy provisions, and those could be included, as Amanda pointed out earlier, in OMB guidelines. OMB has historically had guidelines on grants, grant making, and so forth, but these do not need to be made in binding regulations. Next slide, please. Okay, this slide has a lot of really little numbers and words on it, and it's really hard for you all to read. It's hard for me to read. But and I'm not going to walk through this slide or the next slide, but let me just tell you what I've done here. These two slides correspond largely with the key provisions that Amanda addressed earlier. So I've divided them up similarly to the way Amanda presented, with substantive changes, and the next slide, which we'll come to in a minute, is the procedural changes. So while I'm not going to walk through them individually, we are sharing this deck, and so you're going to have all of these. So I'm giving them to you for two reasons. First, as we talked about above, OMB is requesting that you bracket the section number for each comment you're making. Second, you can use these section numbers to search the proposed regulation. As I mentioned earlier, if you download the proposed regulation from what we put in the chat, you're going to get this huge document. Mine was 242 pages. So the first 70 pages of it are a preamble. They're a narrative section. They give you the background on the uniform guidance. OMB states its objections, and they kind of walk through section by section how they're justifying each of their proposed change. And then finally, there's this long block of agency signatories. As Amanda said, a lot of agencies have signed on to this, 41 in addition to OMB. The next 55 pages are the actual proposed rule language. This is the actual language that OMB wants to change in their guidance and codify into a binding regulation. The final 115 pages are how different agencies would implement and change language to their specific regulations. So like I said, what you can do is you can use these numbers, you can go through and you can search by them, and you'll see at the beginning how the description is about why they're making these changes. And then in the middle section, which is the most important section, you will be able to see the actual proposed language. Okay, so now on to the next slide. So this is how to reply by organizations. So for those of you submitting on behalf of an organization, here's a suggested way to approach this. First, quantify the systemic impact. How much federal funding does your organization receive? How many grants, researchers, and programs would be affected? OMB is required to weigh the rule's costs against its benefits. So concrete numbers from real institutions are exactly the evidence that makes the weighing meaningful. Similarly, if you're an association, how many members do you have? And how do you envision this will impact their work? Second, document compliance uncertainty. Walk through the provisions where you genuinely don't know what compliance looks like, such as anti-American values or unlawful DEI, and explain the decisions you face with no clear standard. Regulatory vagueness is important. Third, flag conflicts with existing statutory obligations. I said earlier that I would come back to this. So this rule likely conflicts with Plyler v. Doe on the immigration. Concerning GIPA Section 427, which prohibits the federal government from directing or controlling educational content. This regulation likely conflicts with that. With Title VI's longstanding disparate impact framework, as Amanda talked about. And if your institution receives funding under the CHIPS and Science Act, that's also relevant. That law explicitly directs agencies to broaden STEM participation, which is in direct tension with this rule's anti-DEI provisions. Fourth, describe chilling effects on research. Undefined prohibitions cause researchers to avoid entire fields of inquiry, not just to modify current projects. That prospective harm is often undocumented, but it's really important to capture. And fifth, coordinate, but also submit independently. Signed coalition letters and joint submissions are important, but also file something from your own institution. Your specific programs, your funding history, your compliance track record, those are evidence that no coalition letter can substitute for, and both really matter. And at the beginning of the slide deck, I have my email on there. The National Academy of Education is in the process of working on a coordinated response, and we're really happy to talk to you and help you think through if signing on with us makes sense or if there's a different direction if you are looking for help with a coordinated response. Next slide, please. And this is my last slide. For those of you who are individual researchers, faculty, administrators, or practitioner, your voice matters here in ways that are really different from institutional submissions. First, identify yourself if you're comfortable. You can submit anonymously, and I want to be explicit about that. But if you're willing to put your name and affiliation on it, that strengthens your comment. I'm an education researcher at such and such institution with 3 active NSF grants is your credential. It contextualizes everything you say after it. Second, focus on 1 or 2 provisions you know best. You do not need to address this whole rule. A deeply informed comment on 1 provision is incredibly valuable. Third, quantify the administrative burden. OMB, like we keep saying, must consider costs. Even rough estimates are great. So you could say section 200.305 would add approximately X hours per grant per quarter to my reporting obligations. That's meaningful evidence, and these real numbers from real people doing the work are what we need in the record. Fourth, describe chilling effects on your specific research. If vague prohibitions would cause you to avoid topics, modify your research design, or self-censor, say so specifically. Explain what you would not pursue and why. This is legally relevant. And again, it's chronically underdocumented in comments that are submitted. And I would encourage you to share only what you share publicly and what is therefore already out there in the public record. That's it. Thank you all for joining us. And now I think I turn it back to Dan.